civil society present, my colleagues in the faculty, all protocols observed. Good morning. It's my pleasure to welcome you to our third National Legal Aid Conference on Access to Justice. This year's theme was focused on democracy, and you can recall from the second conference, we agreed that we should always be relevant and make thematic areas in our conference that can help the government to strengthen its institutions, either through rural reform or just through advocacy strategies. So that is what informed this year's theme. And it did not have happened at a better time, because this year we held our election, which was very successful. We saw a very powerful transition, a powerful transition to the next government, very peaceful, you know, and we're back to our work, and this is the reason why we are here. Now, I'm not going to make a speech. First of all, the speech I would have said is a summary on the video, so I'm not going to repeat it. But I will only emphasize that today we are here for a specific purpose: to dialogue, to share our experiences as academicians. They always say that academicians are so far removed from the world, you know, and they sit at some kind of a pinnacle ivory tower somewhere, and they do not have any experiences with what goes around in the society. So for us, because we are supposed to be the key research institutions, and we know in every activity, any development that a government wants to undertake, they need research. Where does that research come from? It must come from the academia, so that it is authentic, methodological, and does not bring confusion. So it is up to us, academicians, scholars, civil society, to work together. Because academicians can't work alone, we also need civil society. They do a lot of work, and we can borrow a lot from their experiences. So when we converge here and dialogue together, there's so much that can we do to change the society. Because after all, we want a society that's equal and just. And how do we get that? By dialoguing and pinpointing areas where there is injustices, where that we can improve to make the society better. Not fighting, but dialoguing. And so I want to also let you know that for the last 3 years, we've been doing this conference. And the conference would not be possible without the financial, technical, moral, emotional, everything from the European Union and United Nations Development Program. And of course, without good leadership of Egerton University management, it would also not be here. So I really, really, really appreciate the support that they give the faculty. You've heard it's a very young faculty, but the support we get from our management is enormous. And of course, with the financial support from our development partners, which I've already mentioned, makes us to be on a roadmap, which we should not be, I think, from the big sisters and brothers law schools, because they feel Egerton is too young, and we should be waiting. We should not try to outshine everyone. But remember, a child must grow, and you cannot curtail that growth. So we are here, courtesy of all present here, and particularly to our donors, and I just wish to thank you again for honoring our invitation and taking your very busy schedules to come and be with us. I thank you, and I wish you a fruitful deliberation, because I know we'll talk more during the conference.
So my boss number one has spoken. I request you to give her a better clap than that, please. Asanteni sana. Thank you so much. Now I'm going to invite my boss number two. My boss number two is one Professor Raphael Mulwa, who is DVC, APD. I will let him even tell you what APD means in full. And I will not even attempt to introduce him because I also have a conflict of interest, even in introducing him, because he's my uncle. Karibu Professor. Mpigieni makofi tafadhali.
Our Chief Guest, Honorable Justice Chemitei, Honorable David Ochieng. Good afternoon, sir. This is the second time we are meeting. The first time I met Bwana Ochieng. He had come for the inauguration of our Vice Chancellor some 6 years ago. Asante, Mheshimiwa. Madam Charity Kagwe, the head of crime and criminal justice pillar at the UNODC, Bwana Jafar Mohammed, project manager, UNDP Amkeni wa Kenya. I've also been seeing that slogan of Amkeni wa Kenya. I didn't know it's linked to you. We need to talk because I know you in a different way. Professor Patricia Mbote, she's being mentioned here as a distinguished scholar. But when I met her this morning, I thought she would remember me. This lady engaged me in an interview in the PSC and asked me questions for 35 minutes, alone. So she's also very good in issues of ethics. That is where she really engaged me in. Karibu, Professor. Christina Gimba, the chairperson of the Kenya Law Reform Commission. Flora Bidali, the CEO of the National Legal Aid Service. Crispin Owiye, the Director Legal in IEBC. And Madam Tabitha Owiye, the Deputy Director in the Office of the DPP. And Bwana Henry Opondo, the Chair of the Rift Valley Law Society. Ladies and gentlemen, with all protocols observed, good afternoon. I want to correct here that I have a nephew that will have to buy a goat in that he has forgotten my first name. I don't blame him. Raphael is his cousin, he's not me. My name is Richard Mulwa. So he's talking of a Raphael that is his age mate. But ours are so many in our family, so sometimes I think this young man gets confused. I first of all want to convey the apologies of our Vice Chancellor, Professor Isaac Kibwage. He's away on official duty in Tanzania, and he requested me to stand in for him in this function today. And so, are you receiving his apologies, please? Asante. And so, from Egerton University, he gave me a speech, but before I give this speech, or I read it for him, I want to say one or two things. Dr. Aura, you are saying you are young. It's really good to be a last born in a university, let me tell you. Because when people start thinking of scrapping faculties so that you do, it's called right sizing, the last borns are spared. Because it is the new thing on the block. And so I'm not worried so much about the Faculty of Law. But for sure, universities are now undergoing reforms. As you're all aware, we are Kenyans. And this is forced because of issues of funding and the strategies for making sure there is some kind of specialization and occupying certain niches that universities are specializing in. But in Egerton, we have a way of thinking about any faculty that we start. So when we start the Faculty of Medicine, we say, look for where your medicine will fit in agriculture, and then we can start the faculty. We also asked Ruth to look for where the law will fit in our agriculture, because we are strong in agriculture and environment. And I think they have managed to do that, in that we are operating in a political environment, we are operating in a social environment, and those two, actually, you can't divorce from agriculture. We find more often than not, when we go to the fields to work with farmers, politics is 75%, agriculture is 25%. But that 25% is what is moving 51 million Kenyans. And so that's an important facet of our lives in Kenya. Another part is this program. I've just been looking and seeing banners in the departments and in the Faculty of Law. In fact, I saw that banner the first time when we were moving Faculty of Law from the town back to the main campus. And I started wondering what Follap is, and Ruth explained it to me. I think you are going too small. And maybe UNDP should start thinking bigger than what Egerton is thinking. I work in agricultural sciences. I used to sit in the lab for a lot of time. But the last 15 years, you don't sit in the lab if you're doing agricultural research. Research needs to knit with communities. And when you talk of communities, don't think of Nakuru County. We are heading now programs that span the whole country, but they are headed by scientists in Egerton. Why am I saying this? We need to start thinking national so that our university becomes a national university in terms of outlook and the ideas that we put across there. And so what I'm saying, I wouldn't mind to hear about Follap in Lamu, Follap in Kwale, where I was born and bred. And that's why I was saying, I was joking with one of our colleagues here, when they hear the name Mulwa, they already decide your geography. My geography is different. I was born in Digoland. I actually am a complex hybrid of a Maasai, I'm Digo, and I'm Kamba. So I'm Kenyan, so to say. Now, with those few remarks, I want to read the speech that has been given here to me to relate to you by our Vice Chancellor. This is a speech given to the 3rd Legal Aid Conference on the theme, Access to Justice During Electioneering Period in Africa in the 21st Century. Egerton University proudly welcomes you to the 3rd National Legal Aid Conference on Access to Justice. The theme of this conference, which is Access to Justice During Electioneering in Africa in the 21st Century, touches strongly on the democracy as a core value of civilization, and in particular, in the realm of human rights. Election is a key component of democracy, as we all believe. It gives people an opportunity to freely choose or elect those whom they want to govern them. The preamble to the Kenyan Constitution exalts the supremacy of the people. So it states, we the people, exercising our sovereign and inalienable right to determine the form of governance of our country, in quote. The statement acknowledges that the will of the people is the source of actually legitimacy to sovereign governments and the preferred mode of governance that we also desire. Significantly, elections provide an environment through which people exercise this sovereign power. In tandem with our constitutional dictates, the Faculty of Law Legal Aid Program, Follap, has continued to provide free legal aid services to the communities to exercise and claim their rights. Through this venture, Follap undertook civic education in Nakuru to inform citizens of their rights around the electoral process in context to the access of justice, among other issues that they deal with. Many residents benefit from this exercise, including some of the leaders who actually succeed in getting elected in our communities. I therefore wish to say that this conference comes at an opportune time to provide a platform through which legal scholars and consumers of legal services across the flanks of the globe can broadly dialogue on issues of access to justice and democracy, as each is a function of the other, and therefore a beneficial mutuality that needs to be developed. Without democracy, there is no justice, and without justice, democracy cannot prevail. And so what we are saying is that a perilous and dangerous state would really be obtaining, especially in a developing state like ours. Indeed, the values of freedom of association and holding of periodic free and fair elections by universal suffrage, as witnessed across the world and recently in our own country in August 2022, are essential elements of democracy. In essence, democracy provides an environment for the protection and effective realization of human rights, which is the hallmark of access to justice. This occasion is significant for us, gathered here today, to discuss issues so critical and fundamental to our fledgling democracy. This conference brings on board critical stakeholders in the justice sector and also in the democratic space. It serves to demonstrate the linkages between access to justice and democracy and the importance of the functionality of the two in society in the 21st century. There's no doubt that access to justice is the foundation of governance systems based on human rights, democracy, and the rule of law. Access to justice is central in the electoral process as the cornerstone of participation, ensuring democratic space is protected and certifying that the electoral process is authentic. This explains the key theme of this conference. The judiciary, as a key pillar of democracy, pronounced itself as an independent arbiter to the electoral disputes in the just concluded election in our motherland, which witnessed a smooth transition of power, as the Dean has relayed here, and a power handover so often desired by Kenyans. This is testimony that the democratic space has matured and the rule of law observed as a key tenet of our access to justice. The key takeaway then from this is that this year, when a credible machinery was deployed for enforcement of the law and dispute resolution, people did not resort to violence and any illegal means to address their issues. This conference then provides a platform for the stakeholders to discuss access to justice during electioneering period, to deliberate on strategies of ensuring access to justice during such processes, to safeguard election integrity and to bolster citizens' confidence to participate in elections. I urge those in the justice sector and the development partners that as we look into strategies for enhancing better electoral processes in the context of access to justice, we should also be alive to the interesting needs and intersecting issues of the citizens, particularly the poor and the vulnerable members of the society, to ensure fairness and justice for all. An election is not an event, but a continuous process. Let us then learn from all its facets to promote democracy and access to justice to the citizenry by strengthening institutions tasked with its management. Even for those who participate and become unsuccessful, the notion is that they have tried and they need to live to fight another day. Elections should not divide us, but be a platform for promoting democracy and the rule of law, and in effect, bring about integration in our societies. Today, let us have an open discussion that is geared towards strengthening scholarship and providing guidance on how best we can improve our democracy and access to justice before, during, and after election in the interest of Kenyan citizens. Through your peer learning and exchange of experiences here, I hope you will identify best practices for prompting access to justice and managing elections, which are pivotal to law and policy reforms in the sector. I'm confident that this conference will come up with innovative solutions to assist our country and our endeavors to provide quality justice to all, especially in line with our democratic principles and values. This is what is envisaged by the Faculty of Law Legal Aid Project, a society that is just and equal, even in the democratic spaces that we function in. A clarion call, therefore, is for us to protect our democracy and ensure access to justice for all. My gratitude goes to the European Union and also the UNDP for their continued support to Egerton University, especially the Faculty of Law Aid Project, and making it possible to host this timely conference. Just as I did in the last conference, I lodge another appeal to the organizers and sponsors of the conference for further support to provide a similar platform for engagement, not only for scholarship, but strengthening access to justice through meaningful collaboration with the various stakeholders in the justice sector. Finally, I want to reflect on the words of the Aga Khan IV. A quote, I say, "The search for justice and security, the struggle for equality of opportunity, the quest for tolerance and harmony, the pursuit of human dignity are moral imperatives which we must work towards and think about on a daily basis." Thank you very much, and I wish you a fruitful deliberation. Professor Kibaki. And with those remarks, I want to say thank you, and God bless you.
Thank you so much, Professor Richard Mulo. Another round of applause to him, please. And of course, the challenge to buy a goat is accepted. We shall meet behind the tent when the visitors have left. All right, let's push this discussion forward. And now I'm going to invite Madam Tabitha Ouya from the Office of the Director. I will be inviting Madam Tabitha Ouya from the Office of the Director, Public Prosecutions, as well as Honorable David Ochieng, who is representing the National Assembly, the August House, right? But before they come forward, I'm going to request that now, it's only fair that these seats be occupied now. So I'm going to request that we have some people moving to the high table, led by our DVC, APD, Mr. Jafar, Professor Mbote, Madam Charity, Madam Lynn, kindly. Of course, our chief guests, kindly move forward and occupy these seats. Mheshimiwa as well. Mheshimiwa David Ochieng. All right. Okay. All right, and then all right, so then now we can have Madam Tabitha Ouya take to the floor to speak to us. Okay, so we can move to Ochieng. Okay, Mheshimiwa Ochieng, tafadhali kuja uongee na sisi. Or should I say kuja uongee na watu wako?
Thank you so much. It's still morning. Good morning, everyone. Habari za mchana. Thank you so much to all the organizers of this very important function. Madam Ruth, the DVC Richard, head of UNDP, head of various government institutions, Platform Commission, National Legal Aid, and all that, all protocol observed. I'm so honored to be part of this discussion. When I looked at the program, I wished I was able to stay here for the whole week and partake of the very deep engagements that I believe you're going to have in the next 4 days. And let me start by thanking the organizers for doing this so soon after elections and bringing together very eminent persons and minds to discuss a very important subject to the country. I got the invite late, so I don't have a written speech, but I will have reflections from what I think is happening in the country and related to the subject. And let me start by saying that we've chosen democracy and elections as our way of forming government and running our affairs. And that is why elections become very important to everyone. Because I've been in parliament now 10 years, and I know how politics decides whether you're going to have a road at a place, or water at a place, or a toilet at a market, or a school anywhere in the country. It's very important, if you think about it, how the way you do elections determines how we live, especially in Africa, where government determines so much that happens in people's lives. If you lived elsewhere, like in a developed world in Europe or the US, systems work. Systems do work. But here, an MP will decide whether you'll have steamer or not. An MCA can decide whether a school will have an ECD class block or not. Because we've given so much power to our elected leaders. And sometimes that power is not checked. And that's why whether elections are run fairly, credibly, and whether elections have integrity is very important. Because that process is supposed to give us leaders who are supposed to have the people's interests at heart. Most of the time, I don't know whether we have people's interests at heart. I'm a politician now, and I can tell you, sometimes I look at how we conduct our affairs in parliament, and you ask yourselves whether we're working for the people or we're working for ourselves. But because these are fundamental issues, I thought I could look at 3 very key areas to make the discussion probably lively. I was asked to make it academic. Unfortunately, I'm not an academic, so I will be as practical as possible in what I'll say in the next 5-10 minutes. First of all, I must say that we have moved very far, very positively, in the way we do our elections. And all of you, from what I heard, are avid readers, if you thought about where we've come from, just pre-1992 to now, there's a time when Parliament was part of the executive, part of the office of the President, not long ago, where the Speaker was decided by the President, the Clerk of the Assembly was decided by the President, our salaries came from the office of the President. That's not long ago. But now Parliament decides everything else by itself. We've got the biggest budget. I was joking the other day that I was telling the Speaker yesterday that I hope no MP travels to Qatar. Because our budget for sports is bigger than the budget for our ambassadors. And our core business is not to play football. So that is how far we've come. As you know, where Parliament was part of the executive, it was time where Parliament now is too powerful, can do things that, without caring whether the things they're doing are in public interest. And so what do I think is the role of Parliament in electoral justice? And again, I will not legislate the law. I will say what I've seen in Parliament for the last 10 years. In 2017, we passed laws about elections, just 6 months to elections. the law on technology and all this. If you remember the Kiraitu Orengo Committee, 6 months for elections, we passed laws, and we are hoping that IBC would implement this law very well about technology, use of technology in the elections. Our elections are very manual, still. Let no one lie to you that our elections are digital, and we say, confirm to you that you go to the polling station, you put your finger there, you identify, then you get a ballot paper and vote manually. So our elections are manual. There is too much ado about technology in elections for nothing. We spend so much on it. But if you checked the role of technology in elections today, it's extremely minimal. We could do without it, and we would still have free and fair elections. But why do we insist on technology? Because of lack of trust. We don't trust anybody. We don't even trust ourselves to run elections where our mothers or sisters are candidates. We don't. So we hope that somehow technology will sort this out. But this technology is run by human beings. That's where the folly is. Somehow we think that technology will transmit results from a polling station to a tallying center, just like that, without questioning who is going to put the form in the system before it gets to the tallying center. And so as you have a discussions, I would request you to have in mind or look at the place of trust, human trust in an electoral process. Of course, lack of trust has history too in the country, but how do we build it back? How do you ensure that in future we're able to trust those who carry out elections? And I don't fear saying some of these things, like in the last election, at what time did you get the new commissioners? The last 4, the Cherera 4. How many months of elections did you get them? Again, that delay was because of Parliament, not anybody else. Parliament. Delaying in making provisions for what's supposed to be done, delaying in making regulations of how that's supposed to be done. So Parliament has played, in my opinion, a very important role, yes, but most of the time we come in very late. So how do we ensure that Parliament is able to do what's supposed to do at the right time? I told you I've not here speech, so I will just speak and bits and pieces of what I know. That the 3 months to elections, the IBC brought to us the campaign financing regulations. 3 months to elections. The law says otherwise. They should bring them earlier. And as politicians, you don't have control on how much we use. So we didn't care what anybody thought. We didn't care what other academics thought or whether campaign financing regulations are important. We said they've been brought late, we will not look at them. That was 2022. In 2017, after we passed the law on campaign financing, we said they will not be applicable until 2022. Parliament said that. So we passed a law on campaign financing. We deferred its applicability in 2022. In 2022, we said they were brought late, so they're not applicable. So I want to look at this as we make our discussions about electoral justice. So where is justice? When Parliament, because it has power to do so, keeps on doing things that undermine the possibility of elections being fair and free. We've had, again in the last elections, and also in 2013, where Parliament makes laws that cannot stand the test of time. 4 months to elections, we passed a law that allowed us to form what we called coalition parties. I'm sure all of you were alive and it's what happened in Parliament. What happens when that time comes, and I saw it in 2017 and 22, is that the political temperatures are very high, people are whipped, and so you must pass the law as proposed, whether you agree with it or not. Like, I would like to invite you to look at that law, the law on coalition political parties, and see whether it will meet the test of any legal scrutiny. And how, for example, coalition formations in the country work with small parties. Well, it's been shown that small parties are more amenable to allowing more women to run in them, more young people to run in them, and more PWDs to run in them. So if the small parties are allowing these cadres of marginalized people to run in them, when they join coalitions, do these PWDs, these women, these young people, do they still get the justice required to enable them run in the elections? Again, the executive interference with elections. When the executive wants to do things, and this started in 2013, still 2013, after the 2010 Constitution, there are so many laws that were made, 3-4 months of elections, and most of them were led by the executive. The same thing happened in 2017 and in 2022. All of us know about the botched BBI process. The BBI had so many good things in it, so many, but had parts on elections and electoral justice that if it had been passed, some of them would have been very good for the country, some of them would have been detrimental. But who knows? There could be another BBI attempt in these 5 years. And so it's upon you to advise us, as scholars, how do you avoid a BBI scenario in future, where, political leaders who have power can decide that this is the way the country is going to go, and because they are following, no one questions. I know in this room there are so many guys who questioned BBI when it was introduced, and people are worried whether it will go to the end or not. I don't think BBI is dead, personally. It probably will arise in one way or the other in these coming 5 years. How do you ensure that in case an attempt like that comes up, we are able as scholars to provide the necessary criticism required to make them work? The role of Parliament in making budgets and budget allocations to the bodies concerned is very important. Every year you'll hear IBC crying, we have no money. In this meeting, we have the National Legal Aid, and when I just came in, I asked our lady Abidali about her budget and whether the budget is separate from the AG's or it's part of the AG's budget, and very important roles being carried out, but subsumed within other budgets. I remember your office, that of Witness Protection, sometimes the one for Law Reform Commission. You have to depend on the AG to get your budget. If you don't get a good AG who will fight for you, you're hamstrung for 5 years or for 4 years, depending on how long the AG is there and how long the government is willing to talk to you. So Parliament, again, must be pushed always. Now, let me repeat this. In most situations where budgets are concerned, I don't see Parliament acting in the best interests of especially justice sector institutions. I don't see it happening. You must help the judiciary. You must help the ODPP. You must help the National Legal Aid Scheme get resources by talking about it constantly, by petitioning Parliament constantly. Don't leave them their devices that, their own salaries, they are big people, they can fight for themselves. Sometimes they can't. If a meeting like this one is able to talk about these things, and when you finish, it's a press conference or a report written and sent. And now Parliament standing orders have been changed to allow public petitions in a manner that wasn't allowed before. So this meeting can decide at the end of this, to present a petition to Parliament as a result of meeting that the following things we think should be changed. Don't wait until 2022-27, please. Give us these things next week when you finish the workshop, or the week after next. Because there are timelines for when a petition is brought to Parliament, there are timelines within which they must be resolved. We must respond to you, we must accept that we received your document, the petition is sent to the relevant committee, and it must be resolved one way or the other on the floor of the House. If we start early, we'll be putting Parliament in a place where they cannot wait until 2027 to start making legal reforms. The judiciary. I think in that front we've moved very far. I only have 2 quarrels with it, which I would want to put to you. Fear of corruption creeping back, especially on election matters, is there. There are a lot of fears about corruption playing a role, and this sometimes is very open gossip about which judge got what in which case. From the High Court to the Supreme Court. You'll be told so-and-so received this, so-and-so received this. I want to request you to your scholars. You guys can write about anything on earth. Think about some of these things. These are not lies. We here will tell you because he deals with petitions. You'll be told how each judge was given this where to determine a case one way or the other. Yet, personally, I can tell you that the judiciary stands in a very good state to midwife our democracy, and they have done so. So if there are areas where we can help bring openness, cleanliness in judiciary, it will be so, so important. Our courts have confirmed so far now that elections are not about numbers. And I'm looking forward to a report in this case that was about access to justice in this area being through the process of elections. From the day the last election is done to the day the next is done, and the process that go after it. I remember I had a petition in court in 2017. I had lost elections by a margin of 247 votes. I was running in a small party that I started, and another party came in and they forced a result. But when I went to court, I didn't question the numbers. I didn't say that I lost by a small margin, let's do a recount, or the numbers were massaged. No. I went to election on something very different. I told the court that I don't believe the campaign process was fair, and therefore I don't believe that the numbers that came out of that election were free and fair. And when we were during the hearing, the judge kept asking me, "You didn't want a recount?" Because I want to see the numbers. I told the judge, no, I have no interest in those numbers. Because I believe that the process of the election couldn't have given us numbers. And allow me just 2 minutes to tell you what happened in my election in 2017. So I'd left, ODM formed a party called MDG. And in that election, a gentleman called Msando was killed. Unknown to me, Msando was from Ugenya. I didn't know, I knew after he had died. And in the campaigns, I was linked to his death. I didn't know him. But the other party said that, oh, David Ochieng is friends with Uhuru Kenyatta, who killed Msando. And that was a campaign through the campaign period. I told the court that I believe that that campaign alone couldn't give us results that were free and fair. And our elections were nullified, by the way. That election was nullified on that basis alone, that the campaign process was not free and fair. That case went to the Court of Appeal. The Court of Appeal confirmed that the campaign period, the campaign that were done in Ugenya that year were not free and fair. Not the numbers. The party again went to the Supreme Court. The Supreme Court also agreed with us. So when we went back to the elections and there was no propaganda about Msando's death, I won my seat back. So I just want to let you understand or know that the process of elections is as important. And as you do these things, look at the process, not just of what I've described, but of how parties nominate women, how parties nominate young people, how we deal with PWDs. And by the way, the biggest culprit after Parliament, in my opinion, in the continuum of trying to ensure that there's justice in the process is the political parties. We do terrible things to our members. Terrible things. That's why you saw in the last elections, and that should also be inquired, the number of independents keep growing. If you check 2013, 2017, and 2022, the number of guys running independents keep growing. And the reason, partly in my opinion, is the confusion in the political parties. I would say more, but I want to leave it at that and request you to give justice to this topic. And possibly, I'm going to insist and I'm going to follow up with Madam Ruth on the report of this workshop and on the areas where we can prioritize reforms early, not in 2027. I'm a beneficiary of Follap and Ruth's fight for good governance. I happen to have a terrible history. So in 2003, I was chased away from the university. And it's Ruth who came to the university and picked me. This is Ruth here. And I stayed with her for a while, here in Nakuru when I served my sentence. So I must say that I'd been chased away from them for 5 years, and so I stayed with her for a while, working in her law firm before I went back to finish my course. And I want to thank you so much, Ruth, for always standing for justice. With those many remarks, may I wish you Godspeed in your discussions and hope that in your deliberations, you are able to also look at the following areas which are fleshed out. One is that there is a process coming up called boundaries delimitation. The law requires that it's done every 10 to 12 years. It's coming up shortly. It's normally a very emotive, very divisive process in the country. I hope you get time to look at it and see how best we can deal with it. Civic and voter education. Again, that cannot always wait until the election time. Ideas on how this can be institutionalized and budgets given to IBC and the relevant bodies early enough would be really welcome. Use of public resources in campaigns. The last campaigns were the worst in terms of using public resources, because on the one hand, we had a deputy president running for president, and who had for almost 10 years used public resources to campaign for the presidency. The other side was a candidate run by the government, in quotes, who could use Air Force choppers and government lodges to campaign. What is the role of that, and how do we stop that in the future? How do we bring back trust in our electoral management system? And the issue of the large number of commissioners at IBC. Think about it. What about if, for example, Chebukati had decided that those 4 are the larger number and cannot announce results? Because the commission was divided into 2, but one side had 3, another side had 4. Do we need 7 commissioners? Do we need 3? Do we need 1? In India, I'm told there are only 3. Kowe will tell us more. And finally, the conduct of the media, especially again in the last elections, where media takes a strong stand and plays a very strong role in campaigning, especially for one candidate or the other. I would say more, but time eludes me. Thank you so much, and God bless you.
Thank you so much, Mheshimiwa. Did you hear him talk about or mention Ugenya somewhere during his presentation? It's because he's member of parliament for Ugenya constituency, okay? Asante sana. Mheshimiwa, I want to thank you so much for your presentation. I will be presenting on fake news, and I just discovered that you have given me an extra slide in my paper, and perhaps I'll be looking for you so we can have a chat deeper on that. Madam Dean, if we have Madam Tabitha Oya, let me know. Or then, okay, so we just proceed. All right. We shall be getting to hear from the UNDP, UNODC, and also the European Union. But before that, I would like to invite one of my mentors, and that's Professor Patricia Kamere-Mbote. I know you are wondering how she is my mentor. I am mentored by Dr. Ruth Aura, and she is mentored by Professor Patricia Kamere-Mbote, and therefore, I am a product of, that's a multiplier effect, eh? Yeah, so at that multiplier effect, I would like to invite Professor Mbote to talk to us. Apart from being a distinguished law scholar, she is also an advisory board member of the Egerton Law Journal. Asante.
Thank you. Good afternoon. I'm just learning that I may be great-grandmother mentor. Chief guest, Justice Mitei, Egerton DVC APD, Professor Mulwa, Honorable Ochieng, our colleagues from UNDP and from the EU, distinguished guests, ladies and gentlemen. It actually gives me very great pleasure to be here. When I was coming in yesterday, I was wondering, did we meet at Naivasha Resort? And I was told, no, that was the journal meeting. But it just shows that there's been consistency in meeting. And there are very few things that people keep consistently doing. And if we had the first Follap meeting at Centrim, Elementaita, and then we went off, and we didn't come back in 2021, and we didn't come back in 2022, there's a sense in which a fervor would have died. But what has happened is that we have this group of people who've been meeting consistently, and they're meeting consistently to discuss issues that they consider pertinent to the growth of law in our country. The issues that Honorable Ochieng was raising are issues that should keep Maxwell Miawa busy for a long time, because he said that is what he does in scholarship. The issues that we keep hearing, the small stories and big stories that the beneficiaries of Follap have been telling us this morning, tell us that there is a lot of things to do. And it doesn't have to be just one law school doing it. It doesn't even have to be a law school doing it. If we as individuals did our part, then access to justice would cease to be a mirage for the majority of the people we work with. Of course, there is the conflict of interest. And you know, I always wonder, when we as lawyers are talking about access to justice and taking law to the people, and I say, you know, maybe we should have a moment of silence and say, do I really mean that? Because if law is taken to the people, who will give you instructions? Because in essence, you need instructions from people who probably do not have law. But I would like actually to say that as lawyers, we would then find other things to do, so that the things that really ail people, what the chief was talking about, they can sort those out without going to court. But we go back to an issue that Honorable Ochieng raised, the absence of trust. And if there is no trust, then we don't trust ourselves to resolve our problems. We don't trust our institutions to resolve our problems, and that actually is costly. The other thing that makes me very happy about the Follap conferences is that they don't just end up as talk shops. There are outputs in the form of journals. And those journals are available, they are rigorously put together. And in fact, some of you here are part of the both peer review, but also editors. We really must ensure that what we discuss is inked. I do know that in our cultures, we are mainly oral. So we like to pass things through the grapevine. But you know, especially for those of you who are in the academy or aspiring academics, that you either publish or you perish. So what isn't written, you cannot say, oh, Mutembei was talking